Uganda. The Managing Director of Uganda, Mr. Johnson Yuta, is also in attendance. I am really thankful and grateful for this, and I am honored and privileged. I had to speak. I have a very strong litigation background, so I really do appreciate mediation, and I am happy that I have attended this, because for sure I have been an ambassador for mediation, but now I am even, I don't know, double ambassador. It is very, I don't know, to listen to that story under 90 billion, but also to preserve the business relationship, which is sometimes taken for granted, but it is a very good thing when at the end of a case, our customers will come back and get another facility or whatever. What I wanted to talk about is, I really hope this exercise can go down to the magistrates' courts for two reasons. One, for Finca Uganda, we are mostly micro lenders, and I know there are many financial institutions like that. That's one. But two, the pecuniary jurisdiction of magistrates' courts has also been enlarged to 200 million, meaning most of the financial institutions that did not have a lot of cases in the magistrates' courts are now going to have to file or to appear before magistrates. So I hope this exercise can go down to the lower courts, and that it is not limited to the fortnight. So thank you so much. I also realize that mediations are helping us with the customers who have been using courts as tools to delay or avoid payment, pointing out technicalities and the foreclosure processes being taken to courts, yet they should not. Now through mediation, such issues are brought on board, and the financial institution is saved a lot of money, but also a lot of time. Then lastly, I want to talk about there's an issue about in-house lawyers. I would like to believe it may not be the in-house lawyers, it's just that we are the face, that we are the ones who come to court, that they are not on board. It might actually be our other officers in financial institutions, and we are doing a lot to educate them about mediation and the importance of producing documents when they are asked for, and information, and coming to court to give evidence. Trust me, we are also ambassadors for this, and we are going to work hand in hand with the Judiciary to ensure that mediation is achieved. Thank you so much.
Court. In 10 years to come, might not be having any cases litigated. It might be 2%. The way to go is going to be what? Alternative justice system, alternative dispute resolution. Invite the ED Bank Association to introduce to us the chief executives who are here this morning. I see everybody looking like a chief. Judges are very difficult people. Judges, they tell us that we are always in such environment. We look aloof. And I think it's because of mediation. So mediation is the way to go. Thank you so much. Yes, my brother, you can go ahead and introduce the chief executive.
Thank you very much, my Lord. We have a number of CEOs and also all the heads of legal. All the members, the 34 members. Quickly, we have Michael Mugabe, who is also the chairman of UBA, Trust Bank. Here. We have the CEO of Pride Bank. But in this particular case, we have seen that 97 cases and 90 billion was unlocked. What better message could we have received from this? And that shows the sheer potential that is in ADR. Last week we had a meeting, and perhaps the governor will speak to it. We have a monthly meeting of CEOs with the governor, and this matter was on the agenda. And the various shortcomings, dedicated officers, their absence and things like that. We discussed them. We are even thinking of one of the KPIs, because bank officers are measured on KPIs. And one of the things we're having discussion on is to measure recovery, legal, and risk staff, and relationship management by the number of disputes resolved through mediation instead of litigation. And so we are taking this seriously. It is a process. The level of appreciation, as you mentioned in your report, it is a journey that through the leadership of the governor, we commit to. It is a journey, and we will preach and preach and practice and put it in black and white. And so I'll keep my remarks brief. We are grateful. This is the direction we all embrace as industry. And once again, we are very grateful. Thank you very much.
Thank you so much. And I also wanted to ask my brother, can I open an account in Bank of Uganda? A personal account. I invite.
Thank you. The Honorable Principal Judge in us an audit. An honest accounting of what a fortnight of mediation has told us about commercial justice in Uganda, and a candid assessment of what it now asks of us. I want to start by thanking the Honorable Chief Justice and the Judicial Training Institute for convening us and for the partnership that has brought us to this point with real momentum. This gathering completes an arc that began at our colloquial in Chico in April this year, continued at the Chief Justice Roundtable with the bank CEOs on 7th of May, and tested in practice at the settlement fortnight held at this commercial division from 18th to 29th of May. Each stage asks the same question, but in a different register. Whether Uganda's commercial disputes will be resolved or merely adjudicated. Whether, to borrow the fortnight's own theme, we move from litigation to resolution. At Chigo, I did set out the scale of what is at stake in plain terms, and the number of the unresolved banking disputes, about 600 or so. At that time, holding an estimated Uganda shilling 7 trillion out of productive use. The Honorable Chief Justice, working from the Commercial Division's own docket, placed the value of pending cases at several trillions. 2 vantage points, 1 conclusion. Too much of Uganda's capital is not working. It's not financing the trader's next consignment of goods, the manufacturer's next production run, or the farmer's next season. It is waiting. Waiting on a mention date, a ruling, and an appeal. Capital, like blood, serves the body only in motion. Hold in one place, like in commercial courts. However, like the police, it does not do the economy no good at all. The fortnight gave us a reason to believe motion is possible. The statistics that were read out by the Honorable Justice and the head of the High Court Commercial Division is a testament to this. This is not a courtesy extended to litigants. It's a rule that they can rely on. And in matters of credit and capital, reliability is worth more than a sentiment. The Bank of Uganda came to this fortnight not only as a convener, but as a litigant. In our capacity as a liquidator of the closed marketed Credit Bank Limited and the EFC Uganda Limited, we brought forward disputes that had, in some instances, outlasted the institutions themselves. We left with 3 consent judgments and a further suite of settlement proposals still under negotiations. Parties who once at the same table could design tailored repayment plans and negotiate interest concessions that no judgment, however sound, would have troubled itself to craft. This is what mediation does, and adjudication cannot. It feeds the outcome to a relationship that, in banking, usually has to continue. So, an exit meeting to be what is named. We must also be honest about what is still resisting us. Colleagues, you all agree that concept judgments still take longer to execute than the mediation that produce them, slowed by layers of internal approvals within our own institutions. Procedures still exist and insist in places of physical appearance where a signature or a video link would serve well. And some borrowers, frankly, still treat mediation as one more delay to be run out rather than the off-ramp from litigation that it is designed to be. None of this is a reason to read from ADR. It is a reason to refine it. On our part at the Bank of Uganda, we will continue to ensure that the CEOs participate in this event. We will take whatever it takes to ensure that they do. To that end, I want to propose 4 priorities for the sessions ahead. First, if we are going to have future mediation, which I believe, I think the window should be extended so that we are not constrained by the arithmetic of the diaries. Second, streamline the concept judgment in chambers or electronically so that settlement reached in the mediation room does not lose momentum in a registry. Third, standardize tiered ADR clauses across financial contracts so that mediation becomes the contractual default, not a concession negotiated out of pressure. And last but not least, screen the cases for ADR suitability at the point of filing so that suitable matters are identified before court resources are spent on them and previous interlocutory applications are discouraged from the outset. These are just modest asks and deliberately so. Judicial independence and prudential regulation each depend on predictable rules, not on ad hoc goodwill. And the fixed judiciary strategic plan for 2025-2026 to 2029-30 rightly places ADR among the instruments for building that predictability, alongside the sector's own ambition to have the case backlog by the end of the decade. Institutions earn credibility the same way individuals do, by doing and consistently adapt what they say they will do. We do not yet have grounds to declare victory. What we have is evidence that the direction is right, and colleagues on both sides of the partnerships are willing to keep walking it. I think the Judiciary, the Judicial Training Institute, the Commercial Division Court, and every CEO, bank, and legal team that treated mediation as more than the formality of this fortnight. I look forward to our discussion this morning, which we have already had, and the sessions that are going to follow next. I thank you all for your attention.
Thank you so much, my brother, and this is his docket. Yeah. So he has taken note of all of them, and it is something that we can do. It is not. And thank you for giving leadership. Leadership is everything in this. The moment this chief executive see that you say it with a passion, and you even.
And I think I had him right. He said the judicial officers should now get interest-free loans.
Yes, I also
Independent and impartial. Thank you so much. My Lord, allow me to introduce you. People may be Honorable Principal Judge, the Justice Francis Apodo. Just wave to the people. Judicial Training Institute. Thank you so much for organizing us. My Lord, some people have met the head commercial division, but allow me to introduce her Lordship. Isaac Bonnet, from the civil division. Thank you for coming. We have her Lordship Linda Lydia Tusime. Thank you for coming. We also have His Lordship Anthony Kwagwire Musana from the Industrial Court. My Lord, we have Mr. Justice Thomas, Mr. We also have the panel, Honorable Justice Kahichi. She's here with us. These people decided to allow me take us through the awards.
Delivering timely, cost-effective, and business-friendly justice. Every matter that was settled represents more than a closed file. It signifies relationships that have been preserved, commercial confidence that has been strengthened, and justice delivered in a manner that allows parties to move forward. We say that disputes can put like a full stop or a comma into our lives, but once it is settled, people can now move on. I want to extend my sincere appreciation to the Governor Bank of Uganda in absentia for mobilizing the bank executives who have been here. Collective commitment made this exercise a success. We would not be celebrating this morning. As we reviewed the outcomes today, we are celebrating the achievements, but we have also candidly taken note of the lessons learned, and we should also ask ourselves what worked well, what challenges remain, and how we can institutionalize best practices so that the spirit of mediation extends beyond the designated settlement sessions. I think we have all agreed to that. Everyone spoke to that. The head of the commercial division spoke to that. My brother Tingu Ego spoke to that. So it is the way to go. We want to make it an everyday case management tool as a judiciary. As a judiciary, our strategic direction is really to promote appropriate dispute resolution. That is our strategic direction. And we reduce case backlog and of course improve public confidence in our courts. If there's anything that the judiciary as an institution should really value, is confidence in our courts. That's the number one thing. Once people lose confidence in the courts, then there's a problem. Then why do we even exist? The commercial division continues to lead by example, and I encourage you to keep innovating and sharing these successes across other divisions and circuits. And finally, I also want to thank all our stakeholders for their partnership and continued confidence in the judiciary. Let us build on this momentum and ensure that mediation actually remains a central pillar of efficient and people-centered justice. My Lord Patience, I am basking in your excitement. Yes, that's why I told you wear blue today, so that I can also associate, you know, that we are one in this. Congratulations, we are so proud of you. Yes. Thank you once again. I say all this for God and my country, and I now want to officially declare this exit meeting open, closed. Thank you.
Principal Judge, let us all rise for the national anthems. So much. So the last photo is judicial officers, managers, and all staff of judiciary. Thank you for giving us the opportunity to have this photo